Hey everyone, it's Rob Ryder. May 4th, 2013. Well, I hope this looks better on your screen than mine because my monitor's going dead and looks like a rainbow. I use a lot of red and blue, but I got greens and all sorts of colors on here. Well, this video is going to be about bits and pieces. A little bit about IRS, foreclosures, traffic, post office, ex parte, and the use of statutes. And my email address is courtofrecord@aol.com. TalkShoe ID 122402, taking clues from ancient books. And I just posted a audio that I had done with Hugh earlier this week, between the 2nd and 4th of May. And so part of what we're going to talk about had something to do with what he had said in his case. But anyways, that's where you'll find the audio. If you didn't get it to you by email, it's been posted on TalkShoe. And if you can, please do donate. My daughter's PayPal account is ashleyrytlewski@gmail.com. You really have to want to give to write all that in there. ASHLEYRYTLEWSKI@gmail.com. Or Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. I didn't make my rent the end of this month. It's already the 4th. Go figure. So, that being what it is, let's just move on. So, one of the interesting things is ex parte, and part of this came up because earlier this week, Bobby in Arizona had called about a complaint he had put into the Justice of the Peace Court, and he wanted to talk to the Justice of the Peace. And the clerk said he couldn't talk to the Justice of the Peace. That would be ex parte. Well, I had put in a video I did a couple of videos ago, maybe, with, the definition of ex parte in Wikipedia, in this one thing I was reading, said it was property. All right, so what does it was talking about an ex parte hearing, so it said ex parte parentheses property hearing. Well, what does a property hearing have to do with talking to the Justice of the Peace? Could have something to do with it. Now, they want to say it has other names, but when you start piecing together little pieces that you have, a month ago or so, when Roe was at the having a meeting with the county clerk in her county, one of the things that was brought up to her was that the chief judge of the county had jurisdiction over all property in the county. Now, what that means by having jurisdiction over all the property is determining who the owner is. Who owns this property? And it's the chief judge of the county that has jurisdiction over the property. So if you want to have a property hearing, you would go to the chief judge. They're the ones that have jurisdiction over the property. And so that's where we're trying to send our complaints to now. It just makes good sense to do it, number one. I mean, if you don't know who to give it to, well, give it to the top judge and whoever else you think needs it. And it's what a brother in Florida did about a week and a half ago on one of the emails I sent out. And at the beginning of the day, his court case said proceeding status, in process or something like that. After he did what he did, which was to take his complaint, and I think first he put it in his court case, and then he took a copy to the court administrator, and then he took a copy to the judge that had set in the arraignment. And he said, well, I'm here anyways. I'm going to give one to the chief judge of the county. And he went up to the chief judge of the county's floor, which was the 8th floor of this building. Chief judge's courtroom, opened the door. All there is chairs in there. There's no planes, right? There's no bench up on top of a higher level or witness box or anything. Just a big empty room, basically, with chairs in it. And 2 windows where you could put paperwork through, and 2 sheriff's deputies sitting in the room. They're basically their coffee on the floor because there's no chairs or no tables to put anything on. And one of them said, how can I help you? And he said, I'd like to leave this with the chief judge. And the sheriff said, I can take care of that for you. Took it, apparently didn't look at it, just walked over, slipped it through the window. And so he gets home. About 4 hours later, he looks online, and instead of it saying in progress, now it says no file. We're waiting to see what happens next. But now there's no file. Now, does that mean there's no file, as there was no complaint filed? Because that was part of the complaint, was they hadn't filed a complaint. There was no sworn complaint. And if you're brought in for traffic, it's a criminal offense. And we'll get into a little more of that later. But um, as far as ex parte, in a case name, ex parte signifies that the suit was initiated by the person whose name follows the term. For example, ex parte Williams means the case was brought on Williams' request alone. Okay, so something that you're doing alone where there isn't another party involved. Many jurisdictions have abandoned ex parte in case names, preferring English over Latin terms of application of Williams and petition of Williams. So a petition is the same as ex parte. Well, a petition is also a form of a complaint. Petitions and complaints are really the same thing. You're petitioning the court for something. And so when you put this petition into the chief judge, who has jurisdiction over the property, so ex parte property, they have jurisdiction, they get to determine the owner. We're going to petition as ourselves, saying that is our property, and who are they to say it's theirs? They're whoever they are simulating a legal they're simulating a legal process. And all that can happen is the judge in that court can issue a willfully false judgment based on perjury of witnesses, because there is no sworn complaint in any case. I don't care if it's civil or criminal. If somebody's bringing you to court, right, you think you're being charged with something. They're saying you didn't do something. Well, that should be a crime. I should only be in a criminal court. But as we'll see with ex parte and what they do to other definitions, let's find out what we can do with it. So in some jurisdictions, ex parte has been replaced with in re, which means in the matter of, such as in re. You used to think that was regards. Yeah, in regards of Williams, or in re, in the matter of Williams. However, most jurisdictions reserve the term in re for proceedings concerning property. So if you see in the matter of and a name, they're talking about the property, not the man, the property. Right? Your all capital letter name is the property. It's always the defendant. If you look on a civil case, the defendant is your all capital letter name, and what it is really is a smaller estate carved from your larger estate, because each of these little things where you have accounts and so forth is each its own little estate, all derived from the larger estate, which was really you signing your name in the first place and creating the money. And so NRE, Latin, in the matter of, concerning or regarding, the usual style at the names of judicial proceedings having some item of property at the center of the dispute rather than adverse parties. So I'm not saying you hit me in the nose. I'm saying that property's mine, and apparently you're saying it's yours. So someplace in all of this, they have to start a case and they have to say it's their property, right? Because it's the property that is the dispute. And that all capital letter name you see as the defendant is really an estate, and they're claiming that the proceeds in that estate, whatever is in the escrow, whatever in the box, with that account number on it, is theirs. But it's under your all capital letter name, and everything under your all capital letter name is yours. You are the owner. You just don't have legal title. And we'll see how that plays out in a minute. For example, proceedings to determine various claims to the assets of a bankrupt company could be called in re Klein Company, or in the matter of Klein Company, or in the matter of Robert Allen Mertlewski, right? Whatever it is, with an account number. Sometimes in re is used for proceedings where one party makes an application, a petition to the court without necessarily charging an adversary. And I think this is what they're doing. They're going to the chief judge and they're putting in a petition saying that that's their property. And that's where this other case is that we can't find, the original case that started the proceedings. Because when you go into this court that you're going into, It's not a court. They don't use any court seals. It's all done by the clerks. It's all administered. And really that's because you don't hold the legal title. You're in an in rem jurisdiction, and in rem isn't quite the same as in re. Close, but not quite. We'll see in a second. So I think they go to the chief judge first, and that's where the case is we can't find. And we can go to the chief judge also and say, hey, in this particular case, that's my property. Because we haven't been given proper notice, as this will show. Okay, sometimes I use proceeding where one party makes an application to the petition without necessarily charging an adversary. This may be done, for example, where a couple seeks to adopt a child. An adult wants to change his or her name. Okay, well, not that that has anything to do with what we're doing, but if you're in a foreclosure right now and you're pro se, and you go look at your foreclosure paperwork, you're going to have the defendant listed up there, which looks like it's your name, all capital letters, but they're going to have you down pro se attorney. Well, if you're the attorney, you're representing the defendant, which means you're not the defendant. Then who's the defendant? The defendant is the property. Such actions may instead use the English translations in the matter of, or in Latin words ex parte. The final decision on the style that's used particular lawsuit is usually made by the clerk of the court. Okay, so maybe you can't use the word ex parte. You could use the word in the matter of. So for instance, in the matter of the defendant, yada yada yada, in civil case whatever, right, that the defendant is your property. So this video isn't about how to write the words yet. It's just the concept, right? So it's the concept. Your property is what the defendant is, and even if you go into court to defend it, you're there as the attorney. So that's in re. Right now here comes in rem. Latin. In the thing itself, a lawsuit against an item of property, not against a person, which would be in personam. So if you're in court, one of the things to ask them is, what jurisdiction are we in? Is this an in rem proceeding, or is this an in personam proceeding? Have the judge tell you. If it's in rem, it means a lawsuit. Then say, well, that means a lawsuit's against the property. Is that correct? Well, yes, it is. It's not against a person. It's against the property. I don't care if it's a criminal case or not. If it's not in personam, it's not against you. It's against your property. So if it's a criminal case and they got your all capital letter name up there, right? It's against the property. Well, how can my property have committed a crime? And this has to do with statutes and so forth. And interesting little tidbits we got this week. I'll continue on. An action in rem is a proceeding that takes no notice of the owner. In rem doesn't care who the frickin' owner is of the property, but determines rights in the property that are conclusive against all the world. It's going to determine the rights because he who holds a legal title is the owner. That's what the law says. And you don't hold a legal title. You have equitable title. In your house right now that you're in, based on what both Bob and Roe had found out, that if you went to the city and just gave him your street address, you're going to find the person before you is the owner. Well, what's that about? How come on the city records, when you give them just the street address, it shows them as the owner? The person before you. In Roe's case, she's been there 9 years. It still shows Elaine as being the owner that was there before. And this is in the city records. Right? So you don't hold the legal title, because if you did, the city records would show that you're the owner. And this has to do with, I think probably in Roe's case, because Illinois is a title registration as opposed to a deed state, they do title registration. And so there's an original certificate of title someplace and an owner certificate of title, which is a duplicate of the original. And whatever that record says is what the court is going to say is the owner. And if you don't have your owner certificate of title, then the original certificate of title that's in the record that the judge uses doesn't have you down as the owner. You don't have your original certificate of title. Therefore, the insurance company, title insurance company, that guaranteed your title and fee simple has never fulfilled their fiduciary duty. And so you make them the defendant and you take it to the chief judge and say, Chief Judge, I have this property here and I'm supposed to have fee simple title according to this certificate I have from the title insurance company. But why am I paying taxes? Right? Got lots of questions for that. So again, it's not the paper we're writing today, but it's the concept, right? I got a freaking certificate that I paid insurance to have title and fee simple. No other words, just fee simple. When it just says fee simple, that's the most powerful form of fee simple. Anything with a word after it reduces its power. But fee simple basically means fee simple absolute, which means you have both the legal and equitable title in possession. Right now, you're the owner of that, of the land that you're on, but you're not in possession of the legal title. Somebody else has a legal title. And who has the legal title in an in rem proceeding is going to be determined to be the owner, conclusive against all the world, because in the office of the recorder, I guess the chief judge, that record up there shows somebody else is the owner, not you. For example, and then back to Roe, and then remember, this is a county clerk who told Roe that the chief judge of the county has jurisdiction over all property in the county. Not saying they own the property, they have the jurisdiction, the right to determine whose property it is. And we're not taking our complaint to the chief judge so far, now we're trying it. And the thing about a chief judge of a county is they don't sit on many court cases. They appoint the judges and hand out the docket stuff. So, they're not an everyday judge in a courtroom. I'm not saying that they're not ever in a courtroom, but day to day, their function is to give everybody else their workload. So it could just be this simple, right? That's where they're going. They're doing an ex parte hearing to the chief judge saying that's their property. You never get the notice of this suit they just started because they're using an incorrect address through the post office. You don't get the postcard to find out. They get a default judgment, and now they're going to come try to collect in another jurisdiction. Seems to me that be what they're doing. The object of the lawsuit is to determine the disposition of the property, regardless of its owner is or who else might have interest. Interested parties might appear and make out a case in one way or another. So again, it has nothing to do with who the owner is, but if you have interest, you might appear and make a case in one way or the other. Well, what they want you to do is go into the courtroom that they're leading you to by the document they've given you that is simulating a legal process. It is not a legal process. Instead of going to the chief judge to say, apparently I never got notice that this case was going on, that has now brought it to this other court. They're going to get a default judgment from the chief judge because you never appeared, never showed any interest. So they're going to say, well, I guess you sure, you did, the judge, they're not going to say this, but the thought is, right? The judge may ask, well, you did do an affidavit of mailing, did you not? Well, yes, I did. Here it is. All right, let's put that in the record. Well, that affidavit of mailing is probably to your true name, which in my case is Rutluski, Robert Allen. And if it went to the true name at some address we don't know, well, we never would have got the mail, and it would then go to lost mail. Which is one of the reasons we're going to the post office, trying to find that lost mail for your true name. Okay. Interested parties might appear and make out a case one way or the other, but the action is in rem against the things. It's against the property. In rem lawsuits can be brought against property of debtors in order to collect what is owed, and they are begun for the partition of real property, foreclosure and mortgages, and the enforcement of liens. So they're going to go not first in rem, they're going to go ex parte to the chief judge, get a default judgment, and then come to another court in rem to say, okay, it's our property, release it to us. They may be directed against real or personal property. In rem actions are permitted only when the court has control of the property or or where its authority extends to cover it. Okay? Permitted only when the court has control of the property. For example, in Kansas may determine rights, okay, only in Kansas, yep. The in rem jurisdiction of the court may be exercised only after parties who are known to have an interest in the property are notified of the proceedings and have been given a chance to present their claim to the court. Present your claim to the court. Take your petition to the chief judge and say, I don't know who these people are, that's my property. You're being tried in a court you don't even know exists, and then led by the nose into a court that looks like a court that's doing an in rem proceeding, and in rem doesn't care who the owner is, just what the record shows should have the rights to the property. And because they've done this other proceeding in secret, in that record it will show that they have the rights to the property, which is why you're not going to win an in rem jurisdiction. We need to take it back to say, no, it's our property. Okay, anyways, enough about in rem and so forth. Use of statutes. If you listen to the call I did with Hugh, now Hugh has, him and Noah is his son. Hugh has already lost his house, and so he had put in opened his own civil action. At the time, looked like that was the thing to do. All right, we were trying to get to the Court of Chancery, and we could see windows that said the Court of Chancery, and when you looked at the documents that had equitable relief on it, it said, oh, this is the Court of Chancery. But come to find out, they're civil actions, and anything that's an action is going into a court in law, and I don't want to go to a court in law. I want to do a petition / complaint into a court in equity. Anytime you're doing a petition, it's going to a court in equity because you're looking for some kind of equitable relief. Lawfully, all law can give you is damages. That's why they always ask you what's the value of the property as a damage. I don't want the damage, I want the property. Right? I don't want them to keep the property, I want the property. And so when he had put his in the first time, the attorney came back and his defense, and I've asked Hugh to send this to me because I don't think I got a copy of what the attorney put into the court, but in a nutshell, the attorney's defense was that you couldn't use a statute against him. So the attorney's saying you can't use a statute against him, and the judge agrees with the attorney. At the time, Hugh's jaw drops. So what the hell is this about? I can't use a statute against him. So he had to amend his complaint, and he had done that, and now he's in another hearing. So that hearing was some weeks ago, and this next hearing was on the 30th of April, and it's with a probate judge, a different judge, and nobody showed up, and Hugh's there by himself. And so he asked the judge about that, and the judge said, well, technically she's right. You can't use a statute against a person, but you can I guess you can't use it against a man. I don't know if that'd be the right way to say it. Maybe we should say you can't use it against a natural person, but you can against a corporation. So that is more evidence that when they're using statutes against you, they're going against your corporation, your estate, your all capital letter name. It's a property hearing. And so that's a defense to put on your paperwork. You can't use a statute against a living man. They're only used against corporations. And that kind of makes sense because, ordinances are used against natural men. Statutes, I guess, against the corporations, and ordinances against living men, or at least the natural person of a living man. So, And then in Noah's case, now Noah had put in a complaint into the court case that um, these should all be posted on Rob Quarter Record. Is that what it's called? I can't even remember what it's called anymore. When I send an email, it has it on there, the name of the blog. Um, but Noah's complaint was pretty straightforward, right? That they had not filed a complaint under oath. They weren't following procedures, had all sorts of things, and we were charging them for crimes. And the judge said that was, pretty serious stuff. And then he pointed out, though, that on one of the services that for mailings, I guess, that Noah had done, that there was either it was the attorney's name was incorrect or the name of the bank was incorrect. And so he pointed out, he made the change, and so they said, well, what do we do now? And he said, well, the best thing to do is give him 28 days. That would be the right thing to do because this had been an error. Basically, the judge corrected the error for him. That's beautiful. And now that bank, prosecuting attorney, right, the debt collector has to answer this complaint. And the judge giving him 28 days. Now, I think they should take those complaints and take them to the chief judge. Already done this, chief judge, right? All that can happen in this courtroom down here is in the courtroom I'm in now, where this civil action is taking place, all that could happen to me is a willfully false judgment based on perjury of witnesses. It's my property. And so I want to work on a complaint to put together to send to a chief judge just for real estate, and see how that goes. So now Bobby in Arizona, his is a little bit different. He had a traffic issue, and we'll look at the documents that go with traffic as far as Arizona is concerned. So we had pointed out these procedural errors they were making, and basically that they were simulating a legal process which could only lead to a willfully false judgment based on perjury of witnesses. And he had submitted it, mailed it to the Justice of the Peace of the Justice of the Peace Court out in Arizona. So he called, I don't know, 4, 5, 6 days later, and he talked to the clerk just here at the end of the week. And the clerk told me that he could not talk to the judge, that it would be ex parte. Well, again, ex parte is property, right? So what do they mean by ex parte? I can't talk to the judge or the Justice of the Peace because it's ex parte. So what we did then is we said, well, let's write one to the chief judge complaining about the Justice of the Peace and put the complaint in that started the whole thing and send it to the chief judge. Well, he just called me a little bit ago, and he said he got the postcard back today for the return receipt for the certified mail, and we had mailed it to the chief judge, and he said on the return receipt it has both a signature and a name, block name, right? Like really how it should be. You should have a signature and then a line and then a name underneath it. Normally that would be the proper way to do it. Right, the cursive name and the whatever non-cursive is, just spelled out name, block name, and it was stamped on the postcard. And he said, the other ones that he sent out, like to the justice, it just had a signature on it. And I think if we were to look deep enough, we would see that a signature isn't enough. It needs to be a signature, and it needs to have the person's name spelled out underneath it, so we know who it is that's signing it, because we can't read everybody's signature. If that makes any sense. Just, something different that happened. So, what was going on with Bob? What was going on with Bob? Where were we? Okay. This is a Arizona traffic ticket and complaint. And this is what they fill out. And I did a video on this already, so I don't spend too much time on it. But down here in this corner, this is where the cop is supposed to put, I certify that upon reasonable grounds, I believe the defendant committed the above violations, and I have several, or served a copy of the complaint upon the defendant, and he's supposed to sign it. put his number on there. And then over here, you're going to sign that you're promising to appear. So really, what you're going to find out is that this is just really a promise to appear. Because this block here, where it says I certify, is not as prescribed in the court rules for Arizona. And that is right here. So in the Arizona Criminal Code, first of all, what a complaint is. A complaint may be laid before a magistrate. That person has threatened to commit an offense against the person or property of another. When the complaint is laid before the magistrate, he shall examine on oath the complainant. Again, complainant has to be there, and any witnesses. Well, there cannot be any witnesses unless there's a complainant, first and foremost. So there can't be a complainant witness without a complainant. And if there is just reason to believe the commission of the offense was threatened by the person complained of imminent, the magistrate shall issue a summons or warrant of arrest, yada, yada, yada. Okay? The complaint stating misdemeanor charges laid before a magistrate under provisions of whatever, or filed with the magistrate under another set of provisions, need not be sworn to if they contain a form of certification by the attesting officer in substance as follows. So this has to do with, these other ones here have to do with traffic issues. And it needs to say, I hereby certify that I have reasonable grounds to believe and do believe that the person cited herein committed the offense described herein contrary to law. But that isn't what this says. Committed the above violations and have served a copy. Committed the above violations. Oh man, this is getting bad. My color's really fading fast. I don't know if I'm going to have a computer monitor next week or not. I hereby certify that I have reasonable grounds to believe and do believe that the person cited herein committed the offense described herein contrary to law is not what it says on here. Therefore, he would have to go and, because it doesn't have the right certification on it, it needs to be done under oath. So he would have to take it before a magistrate. A false certification under the provisions of the subsection A of this section shall constitute perjury. The dude just committed, if they fill this thing out here, they just committed perjury. It's a false statement. Doesn't meet the criteria. Violation, an act done unlawfully and with force. See over here, they're charging you with a violation. I thought you were driving a car, right? And what's a violation? I'll get back to where it is. There you are. An act done unlawfully and with force. They said you did a violation. Violation means you did it with force. I think you were just driving a car and had a tail light out. But to arrest without a warrant, this is what they need to do. A person arrested without a warrant shall, without unnecessary delay, be taken before the nearest and most accessible magistrate. Right? So normally when they're picking you up on the side of the road, they don't have a warrant, do they? So they're supposed to take you before a magistrate. And a complaint shall be made before the magistrate, setting forth the facts, the basis of his statements of facts, showing the offense for which the person was arrested. And again, because it's a complaint, and it said earlier that a complaint was sworn under oath, the cop would have to take you before a magistrate and swear under oath that you committed the offense. Well, they don't do that. The provisions of subsection A of this section shall not apply where a person making the arrest is a peace officer and decides to proceed under the provisions of this next section. Okay, so they don't need to go before the magistrate and do a complaint the way it says. They could do it this way. Notice to appear and complaint. In any case in which a person is arrested for a misdemeanor offense or a petty offense, now again, this would have to be your natural person for a misdemeanor. All caps can't commit a misdemeanor. And when you look at your paperwork, it's going to have all caps on it, so it's in rem anyways. But This is just how bad they don't follow their own laws or their own procedures. The arresting officer may release the arrested person from custody in lieu of taking the person before to a law enforcement facility by use of the procedures described in this section. At any time after taking the person arrested, so you are arrested, for a misdemeanor offense or a petty offense to a law enforcement facility, the arresting officer, instead of taking the person to the magistrate, may release the person from further custody by use of a procedure described in this section. So in either case, either on the side of the road or after they've taken you to a law enforcement facility, instead of taking you to a magistrate, they can do the following. And the following is this. If a person is arrested for a misdemeanor offense or a petty offense and the offense is listed in, the person shall not be released pursuant to section without giving a thumbprint, fingerprint, right index fingerprint. Okay? But that's only for that one particular section. In any case in which a person is arrested for a misdemeanor offense and a petty offense, and the arresting officer may prepare in quadruplicate a written notice to appear and complaint. Two things, notice to appear and a complaint, containing the name and address of the person, the offense charged, and the time and place where and when the person shall appear in court provided. Anyways, the arrested person, in order to secure release as provided in this section, shall give his written promise to appear, right? All you're doing is promising to appear. And one copy of the written notice and complaint. Should be a notice and a complaint that you're given. The officer shall deliver a copy of the notice and complaint to the person promising to appear. As soon as practical, the officer shall deliver the original notice and complaint to the magistrate specified therein. So on the complaint, when you see it, there should have been a magistrate already specified within the complaint, or they're not following procedures. Thereupon, the magistrate shall promptly file the notice and complaint and enter it into the docket of the court. You could use this traffic ticket for the same thing. If the traffic ticket had the correct certification, but it doesn't. So it's not that they've charged you with a complaint. They're getting your promise to appear. And then F, when a person is given his written promise to appear in court upon a designated date pursuant to this section and thereafter fails to appear personally or by counsel on or before the date, so you don't need to wait to that date, you can go to the court any date on or before the date, the court clerk or other court staff shall file a complaint in writing under oath setting forth the offense and knowingly violating a written promise to appear in accordance with that section. Now, why is that important? That one section there about on or before. If you don't show up, the court clerk is going to, under oath, file a complaint. Well, because when Bob was talking to this clerk, he asked her about this. He said, well, if I fail to appear to a hearing, do you file a complaint then to under oath because I didn't show up? And the lady says, oh no, we just do it right there. Right? They don't go file a complaint under oath. They just issue a warrant. Right? She admitted to it to Bob. Now, she thinks that's just the way it's done. And Bob is explaining, well, that isn't what it says in this rule, and she doesn't have a clue about the rule. You know why? Because they don't know their procedures. Well, I spent 10 years in the Army, right? And not following a procedure will get your ass court-martialed. It doesn't matter that you didn't read them. What matters is you didn't follow them. Doesn't even matter if you did read them, if you don't follow them. Right? You can be court-martialed. So, long story short, we took the complaint that Bob had sent to the Justice of the Peace and we wrote a short complaint to the Chief Judge, and he mailed it to the Chief Judge, and on the return receipt he got today, because they got it yesterday, on the return receipt he got today, it had both the signature and the block name of the person who was receiving the paperwork. It wasn't the Chief Judge, it was, I guess, whoever gets the mail for the Chief Judge. Okay, IRS. What about the frickin' IRS? What do you say about that? Oh, okay. Where are we at here? So, here last Monday, I'm sitting here researching some stuff, and my son-in-law says, "Hey, Bob, there's somebody here in the driveway." And I said, "Oh, maybe that's the postal inspector." Because about 2 weeks before, I had submitted a complaint to the postal inspector saying that this mail that the IRS was sending me was sent to a fictitious name and that they were simulating a legal process. And I did a video on it. Um, so I was hoping to hear from him. And I walk out there and, well, no, it isn't who it was. It was some gal. Where's her card here? Sean Delaney, IRS. Are you Robert? I'd like to talk to you. Well, yes, I am. And she said, okay. Well, I said, can you step out to my vehicle? Um, I said, sure. I'll be out there in just a second. I want to grab something. So I wanted to come in and grab the complaint I'd put into the post office. So I came in and got it, and I went to her car, and I'm walking out to her car, and I can see she's sitting there with her, book open, looking at papers. And I said, you know what? I bet you she has a recording going on in the car. So I walk up to the window, and she hands me something and says, according to this, you owe the IRS like $240,000 or something like that. And I look at it, and of course, the name on it is Robert A. Rytlewski. Well, Robert A. initial, Rytlewski doesn't exist. Robert Allen might. Robert Allen does exist. Robert Allen Rytlewski may exist. But Robert Allen certainly exists. But Robert A. Rytlewski is definitely a fictitious name. So she hands it to me. I said, well, no. I said, this is to a fictitious name, Robert A. Rytlewski. In fact, and I handed her my complaint, I filed a complaint with the postal inspector because I believe it's mail fraud to send mail to Robert A. Rytlewski, and that you're simulating a legal process which could only lead to a willfully false judgment, perjury of witnesses to take my property. And then she hands me what looks like my Social Security card, right? She said, well, isn't this you? And I said, again, that's a fictitious name. I said, it may be my property, but it isn't me. I'm Robert Allen Rytlewski. That's what my birth documents say. Again, you're trying to simulate a legal process, right? And that's fraud. And then she says, oh, so you're one of those tax protesters. And I said, well, I'm not protesting taxes. In fact, I wrote the IRS twice asking for an audit. 2.5 years ago, 3 years ago, and you wouldn't give me one, so I wrote the Inspector General of the Treasury. And he had an agent call me about 10 days later. We sat down, I had coffee, and, he pretty much agreed with me. I said, your 6209 manual, Section 2, which would be about page 25 of the 2013 version, lists all the forms and documents of the IRS and what class tax they pertain to, and all W-2s, W-4s, 1099s, and most other ones that I would be involved in are all classified Class 5 gift and estate. I guess I've made a mistake in the past or was led to make a mistake in the past, and that's why I want the IRS to do an audit, correct the forms, take what I had put on as income and put it down where it goes as gift and estate. If there's any excess after the taxes are paid, send me my refund. And a lot of this is going over her head. But finally it got to the point, she said another thing. I said, well, what I need to know is, do I have a contract with you or the IRS? Because all I can see is something that I've signed that's a graven image. I don't see where you have signed anywhere. We don't have a contract. You're trying to enforce a legal one. And if this goes before a federal judge, because this is what happened in the past to Doug in Michigan, I'm going to say to the judge, Honorable Magistrate, I accept your oath, I bind you to it, remind you of your fiduciary duty, and extend you my sovereign immunity while carrying out my orders. The plaintiff is trying to enforce an illegal contract by simulating a legal process to take my property from me. Now, Doug didn't say all that. What Doug said in court was, I accept your oath binding to it, reminding me of a fiduciary duty, stating my sovereign immunity. And as he said that, he could see the prosecuting attorney's head go into his hands and the judge's jaw drop. And the judge finally caught himself and he said, well, thank you very much. Why don't you go have a seat in that room over there and we'll send this IRS guy in just a minute. So Doug left the court, went and sat in a room, out in the private. A little bit later, the IRS guy comes in and, he's kind of wide-eyed and he really wants to know what just happened because he doesn't really know what happened. But what he's telling Doug is, look, I can make this go away. I just need you to write me a letter. And they discussed what would be in the letter. They went back in the courtroom and the judge said, you guys work it out? And they said, yes, they did. And then he said to Doug, and this is important, he says, is there anything else we need to take care of today? And judge said, no, I guess that's it. He said, okay, done. Boom. Well, what he could have said was when the judge says, yeah, judge, you can give me back my property while we're here. Because again, they're charging your all capital letter name, simulating a legal process. Didn't really know what to make of that at the time, but so then Doug wrote this letter. The IRS wrote him back and said they're no longer pursuing the cases. Now, Doug's never shared that letter that he wrote, and it very well could be he had to give him some kind of non-disclosure statement, right? But he didn't have to. They said he had to. And so he did, right? Took care of it. But I've never seen the letter that he wrote to get the letter from the IRS saying that they were no longer pursuing the cases. But I'm sure that what he's telling me he did in court is exactly what happened. He'd have no reason to lie about that. The fact that he hasn't shared the letter is for whatever reason, but I'm not going to question the fact that he said what he said, the judge said what he said, the attorney reacted the way he did, and the poor IRS guy, did whatever the judge told him to do. So back to my situation. So now she leaves. And I'm sitting here saying, oh shit, it really pisses me off. She just disturbed my peace and kind of changed my whole week. I hadn't planned on them showing up. I thought it would be the postal inspector. And so, since I had before, I went to the website for the Inspector General. Actually, it's called the Treasury Inspector General for Tax Administration. And this is their reply to mine, but here's my, and you can do this online. So when you go on there, you're supposed to put the people, what their names are and so forth. So I'm going to do it this way. Put her down. What's her function? She's an instrument of fraud. Grand Rapids, Michigan. Complaint. On 17th of April, I left a complaint with the postmaster of the Greenville, Michigan Post Office, 48838. I was told it would be forwarded to the postal inspectors. I have yet to receive any indication that the postal inspectors are investigating the crimes pointed out to them, including 39 U.S.C. 3003 and 3004, 18 U.S.C. 1841 and 1842. Their lack of response is very disturbing. Point one of this complaint is that the IRS is committing mail fraud by using the U.S. mail to send instruments of fraud via fictitious names evidenced by certified mail number, which was the envelope I had. And in that envelope it says Robert A. Rutluski in the window. Robert A. Rutluski is a fictitious entity. For the record, my given name is Robert Allen. My true name, by operational law, appears to be Rutluski Robert Allen. My natural person's name is Robert Allen Rutluski, and my legal person's name is Robert Allen Rutluski, all caps. These are my property, and I claim paramount rights, title, and interest in the lands and estate they represent. Today being Monday the 29th, one Sean Delaney, a revenue officer, ID number of the corporation perpetrating mail fraud, disturbed my peace in an attempt to continue the fraud. I informed her of the errors or omissions of the IRS and their refusal to correct the record, as well as her error in considering me a tax protester. I have no protest with general lawful taxes, but a Class 5 gift and estate item has an exemption far exceeding any amount I have ever received, and due to false and misleading information, the amounts of these Class 5 forms were entered as income instead of their proper gift and estate line. All W-2s, W-4s, 1099s are Class 5 gift and estate according to the IRS 6209 manual for the year 2013 as pointed out in Chapter 2. So if you put into Google IRS 6209 2013, you'll find the PDF. If you go to Chapter 2, which is about page 25, it'll start listing all the different forms and what the tax class is. And then if you go to Section 4, which is about page 65, it'll explain on the first page. I think that's DNL. I can't remember what DNL means right now off the top of my head. But it explains what all these different classes are that they're using in Section 2, like 1 through 8. And 1 and 2 are income. And most of the other ones are something else, but 5 is definitely gift and estate. Further, I told her I had contacted your office a couple years ago because I had written the IRS twice for an audit of all the returns to correct the mistakes they had, and they had not replied. Special Agent John Street of your Grand Rapids office called me a few days later. We met. I explained my position. John said words to the effect, my position was one of the most intelligent explanations he had heard for why a man believes what he believes. For the record, I was born on a federal enclave, a natural-born citizen of the United States of America and the several states, not a state citizen. America is a Christian nation, and I am under the laws of natural justice and equity, not Protestant legalism, or the laws of Moses and the Pharisees. If necessary, I wish to take an oath of allegiance to the United States of America, rejecting my unwanted Michigan citizenship, and receive my properly recorded certificate of citizenship showing my domicile to be a municipality within a state. These are all things I've talked about before. I accept the oaths of all holding solemn office of magistracy, bind them to it, and remind them of their fiduciary duty to the faithful, living by the laws of God and under His protection. Sean Delaney and the corporation she represents are trying to enforce an illegal contract by simulating a legal process that could only lead to a willfully false judgment and perjury of witnesses, as no one has filed for a record a sworn complaint that I have harmed them or their property. I claim the King's peace and demand that you protect my peace from any further trespass against my property or me. I'm a victim of identity theft. By operation of law, my true name appears to be Rutluski Robert Allen, and my mail is lost or stolen. I just think that's the mail we're not getting. It's addressed to your true name by operation of law, which is Rutluski Robert Allen, and he now has an address that I don't know, so I can't change it. I can only assume the mail's lost, and I've asked the post office to go find it. I'm a victim of the use of mails to commit fraud and swindles. I need your testimony on what you're going to do about it. That's what I wrote to the Inspector General. And the next day I got this back. Thank you for the information you provided to the Treasury Inspector General. The office will review your complaint, and they did give me a complaint number. I guess it is not in here. Their responsibilities include investigation of criminal impropriety with the Federal Tax Administration and serious misconduct by Internal Revenue Service employees. Okay, well, hey, I gave them something to work with. If they have any questions, they can call me. But the last time I did this to this office, I did get a call from a Treasury agent and talked to him for an hour and a half. And when he showed me a copy of a money order that I had done, I said, well, is this one of your money orders? I said, well, no, John. Mine had a blue ink signature. It was never returned. They accepted it for payment. As far as I'm concerned, the one you just handed me is a counterfeit. And his agent buddy said, well, why is that? I said, well, it's a full-size replication of a negotiable instrument. If I did that with a $20 bill, you'd chase me all over America. So, I don't know what's going to happen with this next, but for those of you with IRS issues, just look at your paperwork. You know, your name with the middle initial doesn't exist. It's a fictitious entity. And maybe it's only used at the federal level. I'm not really sure, right? Maybe the state uses, all cap with all of it, and they just use the middle initial, and that's what the separation is. Either way, it's a fictitious entity. And so if they're mailing you information to it, Well, here's one thing you do. You can put a complaint into the Inspector General. And just hold firm to the fact that the 6209 manual says it's class 5 gift and estate, and if somebody isn't going to put it under oath that you're incorrect, then that's what it is. So what are you bothering me for? I want you to give me an audit. So I was talking to Bob in Massachusetts about this, and he did the same thing, and got the bright idea that he would send a copy also to his IRS agent, saying to add this complaint to his file, and he faxed it to her. And I haven't talked to him since to see if she called back, but beautiful idea. Here, let's enter it into this. Let's just put it right into our file that we filed a complaint against this. So, and then finally the post office. Yeah, I don't know what's up with the post office. 3, 4, 5 of us have put complaints in to the post office the way it says to. Only one has had any contact with the postal inspector. That was Bobby in Arizona, when the dude just pulls up in a black sedan, 2 of them, and he's out picking up trash in the yard or something like that. Not like, hey, let's get together and bring your evidence. No, hey, let's go intimidate and see what happens. But Bob handled it well and wasn't intimidated, and he explained the best he could, because again, he didn't have his evidence in front of him. He's thinking about cleaning up the yard, cleaning up dog shit or something, and now I got to think about my complaint. So, but since then they haven't contacted him, and he's tried to contact him a couple of different times, which led me on that hunt to find some phone numbers, and I sent out a brochure from the IRS, or not the IRS, the post office, that appears to have phone numbers for individual postal inspectors. But because of what happened Monday, my week kind of got changed in what I was going to work on, and I haven't been able to go any further. I guess for myself, I'm waiting to see what Treasury does, since I know they should respond. And I think it's correct to send it to the post office, because it's just correct to do the correct thing. So you can go, when we find out where the one court of justice is, we can take in our evidence that we've been trying to do the correct thing and we've been shot down. Now, it's very interesting what Hugh said in the conversation I had with him, because we were talking about earlier last year. Last year we were looking at the church and going to the ecclesiastic courts, the Court of Chancery, because in reality the Court of Chancery was established by the church, the Catholic Church, get over it, and it was always the Court of Justice. Equity means justice. So maybe the church still has the one Court of Justice. Maybe that's where it is, because we have separation of church and state. However, it's a different jurisdiction than what you're in now, and so we would need to change our jurisdiction. But we had tried sending complaints to the bishops and so forth. In fact, he was one of them that went down and talked to at least the bishop's office about this, and everything he's pointing out is absolutely true. And so I don't know if it was the vicar general or judicial officer, or judicial officer. I'm not really sure, but the guy said, I really don't know what to tell you. They just don't listen to us anymore. Right? Now, his thought, oh, they're just lying to me, right? And you could think that. And, but we could also say, well, that could be, or they could be telling us the absolute truth, and the fact is that they don't listen to them anymore. And that would just show you how far we are into Revelation. So, but what we hadn't tried yet, and it's pretty sound logic that if the county clerk tells you that the chief judge has jurisdiction over all property in the county and everything is a property issue, right? Your all capital letter name is a property. Well, then we need to go tell the chief judge that's our property and have her records updated, because those are the records they use. That's like the office of the recorder. Whatever it says in the office of the recorder is what the law is. And all they've done is they've gone there first and they put a claim into the property, started this case that we don't know anything about. They send out a notice to a fictitious address that we never get so that they can get around this thing right here that would, when they have to go to an in rem hearing, that says the in rem jurisdiction